Good morning, citizens of Oak Island. Welcome to the May 14th, 2025 Board of Adjustment meeting. I now call this meeting to order. The first item is the approval of minutes, which you all have had to study. Do I have a motion to approve the minutes?
So moved.
We have a motion and a second. All in favor? Aye. They are approved. Let's see. Well, there is no old business, so before we hear this new business, I've got a explanation I need to read. The hearing on this matter is quasi-judicial in nature and will be conducted in a manner consistent with courtroom procedures. Members of the board may ask questions of each witness after the witness testifies when questions are called for by the chair. The testimony that witnesses give today shall be taken under oath. If a witness wants the board to see written evidence such as reports, maps, pictures, or other things, he or she should be familiar with the evidence and should explain the document and ask that it be introduced during the testimony. Any attorneys who speak should not give factual testimony, but may summarize their client's case. After all the testimony, the board will deliberate and make a final decision based on substantial, competent, and material evidence in the record. The board cannot make its decision based on evidence or information that is not part of the record. The final decision of the board will be in writing and will include the findings of fact and conclusions of law. Anyone who wants to testify in this upcoming hearing should have already signed up on the sign-in sheet. If you wish to speak and have not signed up then, please sign up now. Once everyone is signed up, the town clerk will ask everyone to come up and be sworn.
So, Mr. Chair, we don't really use a sign-in sheet, or we haven't used one for Board of Adjustment meetings. I don't know if we want to do that in the future. I think if we had a large group, we would, but today there are a couple of folks I think that need to come and be sworn in. So if they would just come forward to be sworn, that'd be fine.
Yeah, we can adjust the script here.
Sure. Yeah.
He lied that comment.
You solemnly swear that the testimony you give to the Board of Adjustment in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
Lydia, it's time for you to,
Okay, so I'm going to discuss board conflicts. Before we open up the hearing, board members should reveal any possible conflicts and withdraw from these proceedings if necessary. Conflicts include, but are not limited to, a member having a fixed opinion prior to hearing the matter that is not susceptible to change, undisclosed ex parte communications, a close familial, business, or other associational relationship with an affected person, or a financial interest in the outcome of the matter. If an objection is raised to a member's participation and that member does not recuse himself or herself, then the remaining members shall by majority vote rule on the objection. Board members should also disclose at this time any information or special knowledge they have about the case. This includes a site visit to the property at issue. So does anyone have anything to disclose? No. Yes, Steve?
I did visit the site several months ago in conjunction with just a visit to see how it had complied with a previous variance that was granted for this property. And I don't specifically recall anything other than a general feeling that, yeah, I guess it complied. I'm also a retired land surveyor and look at the violations reports from the Board of Registration for land surveyors, and did look at the violations report that is referenced for the surveyor that was mentioned in this application.
Okay, and having made those representations to us, do you still feel you can assess the material evidence here fairly and correctly?
I do.
Yes. Okay, all right, thank you.
Okay,
Chairman, if I could make one more notation, please. I wanted to note that we have 4 members present today instead of 5, and I just wanted to note for the record that that was, that information was shared with the applicant before the hearing.
thank you. In this hearing, this upcoming hearing, we'll first hear from the town staff, Brady Golden, then from the applicant and its witnesses, and then from any proponents or opponents to the request. The applicant may, if it chooses, reserve time at the end for rebuttal. Parties may cross-examine a witness after the witness testifies when questions are called for. Again, if you want the board to see written evidence such as reports, maps, or exhibits, the witness who is familiar with the evidence should ask that it be introduced, his or her testimony. Note, by law, some kinds of evidence can only be given by an expert. Opinions about property values and whether increases in vehicular traffic resulting from the proposed use would pose a danger to public safety. I will correct you if you do not follow proper procedures and rule on objections. Before you begin your testimony, please clearly identify yourself and your address for the record. There are no time limits on how long you may speak, but I ask that you be considerate of everyone's time and concise with your comments. Also, I can and will stop any testimony that's irrelevant, not competent, or immaterial. I now open the public hearing. I ask town staff to make their presentation at this time.
Thank you, Mr. Chairman. This is an application for a variance, 101 Northeast 75th Street for a side yard setback encroachment. My name is Brady Golden. I am the planner 1 for the town of Oak Island. So background of the situation, like I said, the subject property is located at 101 Northeast 75th Street. Tax parcel ID 250BD004. It is zoned R6MH, manufactured home. The applicant is requesting a variance to encroach 1.4 feet into the side yard setback from the application is due to a surveyor's error, and the applicant will go into further detail about that. The standard in the ordinance that talks about what the side setback is section 8.6 for the R6MH higher density residential district. It shows that in the dimensional requirements, an interior side setback is 8 feet. Here is an area map of the property located north of East Oak Island Drive, identified in the highlighted parcel above. And here is a zoning map of the same area showing the R6MH in orange, and to the south there is some R6 in purple, and a little bit of R7 down at the very bottom. So here is the initial site plan that was brought to y'all in the first variance request, and it showed that the proposed side setback was to be 12-foot setback from the side property line. It is a little difficult to see as it is being, that 12 number is being shown into the stormwater infiltration trench, but it is indicated in by that red circle above. Here's another survey. This is done after the foundation has been completed. It does identify that the side setback was changed to meet that 8-foot side setback requirement. Although it was changed, it still meets that standard, so there was no problems upon the completion of this survey. And then the third, the final as-built survey is where the problem occurred. And the two circles above show that the rear and the front of this structure do encroach into that 8-foot side setback. We do have an allowance for surveyor errors in our ordinance. Section 8.14.13 talks about the footprint of structures which are within 6 inches or 0.5 feet of the required side yard setback distance and front or rear yard setback distance shall be considered compliant with the requirement of the ordinance if the de minimis encroachment was done in error demonstrated by conflicting surveys. Regardless of any allowances, any expansion of an existing principal structure cannot be outside of the allowed setback. This situation does go outside of that 6-inch allowance, but I did want to let y'all know that we do have a standard for 6 inches or less for survey errors.
Is that it, Mr. Golden?
Other than just going over the variance standards, if you'd like me to read them, I will. If not, we can.
No, we're quite familiar with the standards.
All right.
Does any member of the board have questions for Mr. Golden regarding this request?
I do, not specifically about this request, but about this property. The previous variance that was granted for this property had 2 conditions attached to it. Have those 2 conditions been complied with at this point?
So the 2 conditions, if memory serves me correctly, are on parking and on the recordation of an easement. The parking has been satisfied. That was a part of the approval of the initial development permit. As far as I know right now, no conservation easement has not been recorded, but that is a requirement before a CO can be issued.
Okay.
Does that satisfy you?
That
Any other
answers that
questions
question.
from the board?
Maybe
Okay,
it's just the way the bill, can you go back to that? Is that cited crookedly or is the property line not straight?
It appears that it may be a little crooked.
It's like it's,
Yeah, I mean, the front is 7.3 feet away, the rear is 6.6, so it's not a uniform placement, which happens sometimes. You'll see that on different properties.
That can happen.
Mr. Chair, if one of you would note to enter Mr. Golden's presentation as well as the agenda into the record.
Make a motion to enter the agenda and Mr. Golden's presentation and
into the record.
the information we were granted, given in the.
Do we have a motion
pack.
and a second? All in favor? Aye. The motion, your report has been entered into the record.
Thank you.
Now we are ready to hear from the applicant. State your name and address, please.
Good morning. My name is Corey Sly with Sly Homes. Okay, so initially when we came into this project, the owners had a different builder. So we began and we used their surveyor to start out with, the brochure surveyor. The surveyor had the initial survey for us. We went out there like we normally do and we staked the lot with the forms and everything like that. Surveyor came back, verified those positions and created a foundation survey to ensure that we were directly on the spots. After that, we built the house. We came back and I had my surveyor come and do the final survey because the old surveyor had retired. And now we're here with a slightly cocked house on a property. Those are the chain of events. I don't know if I can answer any questions besides that.
First question that comes to my mind is, he retired or had his license revoked?
From what I understand from my surveyor, he retired before his license could be revoked because there were several incidents where my surveyor had to correct this same issue.
questions from the board?
Yeah, I have a question, and just based on what you said, you did the layout of the house or the surveyor did the layout?
The surveyor staked the corners, the four
The
corners.
surveyor staked the corners.
Yes, sir. And then we came and put our forms up, and then he came back supposedly and checked our corners. And then he wrote up the foundation survey to
But
approve.
he did the initial staking of the corners.
Yes, sir, the corners, metal spikes. And I have, pictures if needed.
Any other questions from the board, staff?
I have just a question, and we don't have any information here as to how close the house on the adjoining property is,
To the right,
to the right.
I would say 15 feet.
8 feet, right?
I don't know. I mean, that, and I don't know that that necessarily would be determinative of a decision, but it would be
Helpful.
helpful information to have when looking at an issue like this.
Have neighbors weighed in
That's what I was
on
going to
this?
say. Yeah, me too. I have a question. What are the neighbors all, especially the one that's immediately potentially being affected by this?
What did they say?
Yeah.
They're actually aware of the issue. They have no problems. They're actually been the coolest neighbors to deal with ever. I think they had a little thing going on with their shed is slightly encroaching. But that, I guess that's grandfathered in from way back when. Who knows how long that shed's been there? But they have no issues at all, and they said they can be of any service if we need like an affidavit from them or something stating they're okay with it. They offered that.
I would have to just comment, there is no grandfather clause on Oak Island. We will now hear from people supporting or opposing the request. Hearing none, we move to the next thing. No one else is here to testify. Any more questions for the witness?
Was the house already built?
I was going to ask the
Yes,
same
ma'am.
question. Stop taking all my questions.
Yes, ma'am, house built.
So how was this discovered after it was built?
Well, we did the time from so we had the initial surveyor sign off on everything. Then when I switched to my surveyor because the other surveyor went out of business. My surveyor found the issue, and we had already built the house. It's a final survey. It was the only survey required at the time. So then we already got a house built, and it's the only thing left to do at this property is get the conservation easement in the back and get a CO. It's the only thing left to do there. Then it's 100%.
I do have one question, and never mind.
I had a
One
question.
more question?
Has the town seen the surveys? I'm assuming all surveys, so you can verify all this was done by Joe Schmo twice, and then the final guy.
Your question is, has the town reviewed the surveys?
Yeah, so we know the surveys were all done as described, because we don't see them.
I mean, we have to, whenever we accept a survey, if it's done by a certified surveyor, has their license and everything, we accept it at face value because they're putting their license on the line when they supply us those documentation. So, I mean, yes, we accept them and look and review, and as long as it's done by the appropriate person, then we accept it.
So it was the builder's final survey that discovered the discrepancy?
That is correct.
Okay, thank you.
Any further questions from the board? There's no further discussion on this case by the board. I will now close the public hearing. And the public hearing is now closed, and the board will go into deliberation. We've heard all the evidence.
I am inclined to grant the variance.
You are inclined to grant it, and are
I am too, just because it's not the builder's fault. It's not the owner's fault. This happened to be the surveyor's fault. It's too bad that he retired before action could be taken against him, but his mistake could potentially cost them a lot of money. So I agree that we should grant the variance.
Yeah, it does seem like the applicant didn't create this
No,
to put it on himself, but and I tend to agree with you, the most important vote is going to be Mr. Uhas. Because absolute unanimous decision is required.
Well, I think it certainly is an unfortunate situation, but I'm inclined to reluctantly but necessarily go along with the other members of the board, and I think this is a situation where a variance is necessary. And so I do think that this request meets all four of the necessary findings. And so on that basis would make a motion that we grant the variance.
And if you would, recall that, just vote on each one.
And then each one.
We want to go by
Yeah,
one by
yeah.
one? All right, so let's do that. As far as an unnecessary hardship would result, I think it's clear that the only alternative to granting this variance would be to move the house, and I think that would be an unnecessary hardship.
How do we vote on that? Do
So
we
that's
agree?
motion one, that the unnecessary hardship would result. What Steve is saying is that it's unnecessary hardship would result, and everyone just vote affirmatively or against that.
agree.
Agree? We are unanimous on that.
I would say the hardship results from conditions that are peculiar to the property. Let me cite the narrowness of the property, the difficulty of citing the house with regard to the previous variance request, trying to work around the tree. So I think that there were certain unique qualities to that property that made this more likely to happen than on other properties of similar size and situation. So I would say that second
agree, and
criteria has been met.
Nothing for the Federal Fair Housing Act
No, but-
applies here.
So I would make a motion that the second criteria has been met.
I second
I
it.
agree.
Second, we're all in favor on that one?
I think the hardship did not result from actions taken by the applicant or the property owner. Clearly, or at least the evidence presented showed that this was an error made by the surveyor upon whom the applicant relied, and not an action of the applicant himself. So I think the third criteria has been met.
I agree.
Okay, all in favor?
Aye.
Yes.
And finally, I think the variance is consistent with the spirit, purpose, and intent of the ordinance. I think granting a variance to allow a slightly smaller than normal setback in this situation would still meet the spirit of the ordinance in providing adequate light, air, and access between houses.
We have your motion in front of us now, and all the conditions have been gone through. And we have the motion and second it, and I think we can all vote now. All in favor?
Aye.
Aye.
Okay, the variance has been approved. We need to enter it into the findings of fact, or what exactly?
It's, if you have voted affirmatively on the variance, we're fine.
Okay,
Okay.
all right. So the town attorney will discuss the next steps for preparing and signing the order of the board.
So I'll work with town staff to get the order finalized, and it'll be signed by our chair.
Okay, at this point, I think the chairman has no comment, but Mr. Goldman has something to report.
Just had a quick comment, and I'm sure it's already been taken care of, but just want to let the board know that we have 2 new staff in our planning department. They are present here today, Taylor and Justice. Taylor is our new planning manager, and Justice is our new planner 1, and you will be seeing their faces more frequently. So,
Thank you, Mr. Goldman.
you're welcome.
Motion to adjourn?
So moved.
I moved.
Make it so. Thank you, everybody.
Did we?